Good morning, everyone. Welcome to the 2013 CLA Spring Conference. I think we have a fantastic program today. It's getting trickier and trickier to know everything there is to know about criminal law, so we've decided to give up. And we're just focusing on some very, very specific points that hopefully when these things, which I think are fairly commonplace in our practice, pop up, you'll be ready for them and 2 steps ahead of the Crown Attorney, hopefully. Not you. We have, in addition to the people who are scheduled to attend here, not all of whom have the best of alarm clocks that you guys do. There's about 65 people watching via the World Wide Web, so hello to them. If you have questions, I think you should see my email address across the bottom of your screen. If you don't, it's bottomley@crimdefense.ca. Email me your questions and I'll do my best to pose them to the panel. I've been asked by our illustrious leader, Mr. Norm Boxall, to remind you to diarize the fall conference, the big brother of the spring conference, November 1st and 2nd of this year. For those of you who are watching online, we had a last-minute update to the materials. So if you hit refresh on the PDF web page, you'll see one more edition coming to us from Robin Parker. And that's all I have to say. I'm really glad to see everyone here. The best part of the conference for me is attending these things and seeing all of the brothers and sisters at the criminal bar sitting together and working together to get better at this stuff that we do. So I'm going to ask my co-chair, the talented Miss Karen Jokinen, to come up and introduce our first panel. Thanks very much, everyone.
Good morning. Our first panel is It's a Line Drive, Impaired by Drugs. And featured on our panel is Kathryn Hall, also known as Kate Hall, from the Barrie Crown Attorney's Office. Probably one of the most fair-minded and succinct crowns you'll ever meet, and extremely knowledgeable. Secondly, beside her is Mike Miller, defense lawyer in Barrie, and okay, fair-minded and succinct, no, but an excellent criminal lawyer, defends a number of very tough cases, and it always seems to be on the winning side. And beside him is Dr. Daryl Mayers from the Toxicology section of the Center of Forensic Science. I've had the pleasure of cross-examining him, and I have to say it is a pleasure because he's extremely fair, he's very straightforward, and he also, if you meet with him in advance, he assists you in terms of your defense. So without further ado, the panel.
Thank you, Karen. Welcome, folks. Thanks for being with us, both folk who are watching on the webcast and those of you present today. Thanks very much for being here. What we want to do today is try and shed some light on how to deal with a case where your client is charged with impaired operation of a motor vehicle by a drug. And while the legislation has been with us for a while now, it seems that there are not a lot of cases yet going through the court system. And we thought it might help if we today went through various stages of the investigation and then the court attendance for trial, just to try and open up some ideas about what we should all be focusing on in assessing the matter. Now, first, I'm going to ask Kate to address various stages of the investigation, dealing with the roadside and then back at the police station. And then a little later, we're going to involve Dr. Mayers. We're going to ask him to tell us what his role is in the investigation and what he's able to say and perhaps what he's not able to say when he comes to court as a witness at the trial. So Katie, if I can ask you, just let's start out. An officer has stopped a vehicle after finding a minor traffic violation, and upon approaching the driver and speaking with him, he observes certain signs of impairment. He doesn't detect an odor of alcohol, though, nor does he detect an odor of any burnt marijuana or see any drug in the vehicle. But he does, distinctly see signs of impairment. What does he do from there?
Well, I should first of all say, just as an introductory matter, I haven't prosecuted one of these drug impaireds yet. Not a lot of people in our office have. I've been involved in assessing reasonable prospect of conviction on a couple of matters and been involved in discussion with the DRE and in pulling those charges because they weren't done to the proper standard. There wasn't a reasonable prospect of conviction, so I can talk about that, certainly. But let's say in this situation, the officer walks up to the car and the driver has pinhole pupils. He's speaking very slowly and slurred, and his coordination is terrible. The officer asks him to step out of the car and he can't stand up. So the officer knows he's impaired, but he doesn't know by what. Because unlike alcohol, you can't necessarily smell a drug. And if there's no sign of a drug, no prescription bottle, no cocaine on his hands or lips, no roach in the car or in the console, then the officer is really left with knowing that there's something impairing in the physiology of the driver. There's something impairing him, but not knowing by what, but also knowing that the symptoms he's observed can be consistent with drug use. So at that point, the Crown's in the position of arguing, if he ultimately goes further with the investigation and the investigatory steps, that the officer might have a reasonable suspicion that the person has ingested drugs or is impaired by drugs. And he can then make a demand for the field sobriety test. This is an investigative tool. It's analogous to the ASD. It's a very low threshold to make the demand. It's one of the investigative tools the officer can use, along with questions. So the officer should have asked, have you been using any drugs? Have you been taking any drugs? In one of the cases that I know about, the officer asked that and the driver denied having ingested any drug but said he's on the methadone program. So that tells the officer that he has in the past used drugs. And is at least using methadone. So the officer, in that case, went straight to the demand. But in this case, he can make a demand for a field sobriety test. There's no right to counsel in those circumstances. It's an investigative tool to help him form, if appropriate, the grounds to make the drug recognition evaluation demand.
So, Kate, the right to counsel doesn't come into play at that point?
No, it's roadside.
And, understanding what you've said about the officer's observations, but absent some visible sign of drug present, I mean, you're going to be bombarded with Section 8 applications, aren't you?
Yes.
Our position being that the suspicion is certainly far less than reasonable unless there's some actual indication of a drug.
Right, by presence of some drug that the officer can see or answers, statements, utterances. Did he say something that leads you to believe he's impaired by drug and not just lack of sleep?
Kate, can any officer make these standard field sobriety test demands?
Yes.
Doesn't have to have any special qualifications, but just any officer?
No, it can be any officer who makes the demand for a field sobriety test, which is a set of 3 standardized tests with a specific wording and a specific way of carrying them out. But yes, training on those, administering those tests should be definitely one of your questions because it's very unstandardized. And these being roadside tests, they're not conducted in a vacuum or in a clean environment. So you're going to have fodder for the ultimate Section 8 on the RPG for the DRE demand wound up with this SFT demand too, because one, what's reasonable suspicion, and two, these standardized field sobriety tests are, the test is standardized, but the way it's carried out may not be, either because of the officer's experience or the environment that he's working in.
So Kate, our officer stopped the fellow on the side of the road after finding the traffic violation, and the road is perhaps narrow and it's dark at night, and so the officer is going to ask the driver to do what?
Well, he's going to ask him to come out in front of the cruiser's headlights so everybody can see. And he's going to ask him to do 3 tests: a horizontal gaze nystagmus test, walk and turn, and one-leg stand.
So the horizontal gaze nystagmus test, that's a mouthful. What's that?
That's looking for abnormalities in the eye movement, which can be a symptom of a certain class of drug being ingested. So what it is the officer will have the person stand, and I'll go through, I'll tell you what the instruction is, and it's posted on your electronic materials. It didn't have time to get it into the written, but it'll be in the electronic version of the materials. You'll see the actual tests instructions on for both the DRE and the standardized field tests posted. So this is the horizontal gaze nystagmus. So we'll have him come out in front of, and I'm using hymns, but it'll come out in front of the cruiser lights and stand there so everybody can see, and he'll say the following. Okay, please stand with your heels and toes together, your arms at your side. The officer demonstrates. Do not do anything until I tell you to. Do you understand? I'm going to check your eyes. Please remove your glasses, if any. Are you wearing contact lenses? Please look at the top of the stimulus, which is the pen, the officer's pen. He's holding it up in front of the eyes. Keep your head still and follow the top of the stimulus when I move it. Only move your eyes, not your head. Do you understand? Right? Then the officer will slowly draw the pen across the field of vision of the subject. And what the officer is looking for, or should be looking for, is the jerky motion of the eyeball, and it's quite obvious. It should not be looking for someone who's maybe staring off, looking at the cars going by just because he doesn't want to get hit. It's not like that. The eye nystagmus is like that across the eye. It's odd, it's weird, and it will be very obvious to the officer, and 9 times out of 10 the officer will not be able to describe it very well, will not be able to make him articulate what it looks like, if it's present.
So the officer is going to tell me that late at night, windy, cold night, traffic driving by, lights, you know, people slowing down as they go by the cruiser and gawking at what's going on.
Yeah.
He's going to tell me that he's focused on my boy's eyes and sees a jerking motion in his eyes as he waves the pen?
Yeah, exactly. That's what he's going to do.
And
good
so
luck. That's what he's going to do.
And so,
Well-
how's he going to conclude that my boy failed the test then? Is it just this?
Well, that's the thing. There is no pass-fail, and the officer shouldn't be telling you that it's a pass-fail. It's a series of screening. It's an investigative tool to gather a whole constellation of factors that lead him or her to believe that the person, reasonable probable grounds to believe the person is impaired by a drug. If this is one of the things that goes into the pot. But the actual eyeball is only one of the clues. The officers are taught there are 6 clues in this test. 3 in each eye is what they're told, because they can move independently if there's drug use.
We don't have the time to go through all the
Yeah.
clues, but the bottom line is, obviously, depending on the circumstances, the environment where the testing process is taking place, it's going to affect the officer's assessment, right?
Right.
And as I understand it, what the officer is trying to do is assess balance, coordination, an information processing ability of the driver.
That's right.
Is that effectively it?
Yep, and that's the same with the DRE, as we'll see. It's psychophysical is what they call it. In other words, the guy, when you said stand with your arms at your side and don't do anything till I tell you, did he start wandering off into the ditch picking flowers? You know, so that tells you he can't process information. He's doesn't care. You know, someone laughing inappropriately or something like that. In other words, they're looking for, can he follow direction? Can he listen to what you've said? And does he do what you've asked him to do?
Katie, he's looking to see if he has reasonable grounds from
Right.
what he observes during these tests. So what if my boy tells him, you know, officer, I just had a hip replacement 3 months ago. I've got bad knees, swollen ankles. I got an inner ear problem. My balance is off because of that. Is that going to affect,
And
you know,
I'm
the reasonable
stoned.
and probable grounds? Where are we?
And I'm really stoned.
I mean,
too,
if I got a
so that's
Section 8,
just
if
gonna-
I got a Section 8 argument set up there because the officer is saying I had reasonable and probable grounds to demand the DRE assessment based on this evidence, knowing that my client has all of these disabilities?
Yeah, of course. And it matters what the roadway's like, and it matters, all those things are factors. And in fact, the DREs are trained not to do some of the tests if there's a physical reason not to. And if they're able to come to their opinion without doing those tests, so be it. But it may be that they're not, and that they don't have grounds, and that they, at that point, if they, your boy, your handicapped boy, who should, now the officer should be checking for the sticker and the.
He's just old and overweight and worn out.
Yeah, I hear you, brother.
All right. Well, look, I'll be honest with you. I feel much more reliable when I hear Daryl tell me that a fail on the ASD is, you know, a reliable indicator of my boy being over 80. I'm much more comfortable with him telling me that than with you telling me that the results of these 3 tests, you know, give your officer RNPG to make the demand.
Right, and the judge will be equally uncomfortable. There is no pass-fail. There is no number. There is no scientific certainty. The officer has to put together reasonable grounds, which should include, at that point, some indication of drug. I'm very uncomfortable prosecuting them when there's no drug in the car, or some admission by the accused. Because impaired by what? None of us should be driving with no sleep for 48 hours, and that will give you a lot of the same symptoms.
So we're at the roadside, the HGN test has been done, the one-leg stand test has been done, the walking test has been done, and the officer comes to the conclusion, you know, the boy hasn't done well, and I've got RNPG to make the next demand. What's that next demand, Kate?
That next demand is a demand for, to accompany the officer for the drug recognition evaluation. There is no particular wording in the code for that demand, but he must understand that he has to accompany the officer, obviously because there's a refusal charge involved in not doing that. At that point, rights to counsel, he is detained and arrested, and rights to counsel come into play. So the first thing when they get back to the detachment is to take care of that.
Now, what if along the way, maybe en route back to the station when my boy's in the cruiser with the officer for 20 minutes, what if he detects an odor of alcohol?
That he didn't before?
Yes.
Great. Well,
Is he going to make an ASD demand now?
oh, please don't do that. He shouldn't do that. He doesn't need to. I mean, at the scene, part of his grounds will have been that he didn't detect the odor of alcohol, and therefore he can eliminate alcohol in his mind as part of the reasonable probable grounds for making the demand. So he should have thoroughly canvassed the alcohol issue at the scene. And most officers, frankly, are trained to sniff that out first. That's where they're going when they have bad driving or those symptoms. That's where they're going, is alcohol.
Don't you find, though, they often find the odor much stronger after they're in the cruiser a few minutes?
Once they get them in the cruiser, that's true. Yeah, because it's warm and it's a confined space.
So Kate,
That's true.
I'm sorry to interrupt you, but we're at the station. Right to counsel's been given. My client's speaking to me. And he's telling me he's there for this DRE evaluation. And so he says to me, you know, Mr. Miller, I just had my hip replacement 3 months ago. I've got real bad knees, swollen ankles, an inner ear problem, all kinds of cardiovascular issues. You know, I'm not likely to perform well.
And I'm really stoned.
And so, you know, Mr. Miller, what should I do? Well, I'm certainly going to tell him to do his best to perform the test. But I guess the question that I'm then thinking about is, my God, do I tell him to answer the officer's questions as to what his medical condition is? Do you have a history of physical ailments?
And just before you do that, because that entails Rule 2 and some ethical issues for the counsel giving advice over the phone and not in a position to see their client, I'll tell you what the DRE does as soon as he begins the evaluation. He starts it off by asking personal questions like what you had for, what have you eaten today, but then it gets a little more personal. Are you sick or injured? Are you diabetic or epileptic? Do you take insulin? Do you have any physical disabilities? Are you under the care of a doctor or a dentist? And you might throw in optometrists there too if you just come from with those jobs. Are you taking any medications or drugs? And then some questions about corrective lenses, those kinds of things. So the once the demand is made, and I should point out this, that there's no as soon as practicable requirement for the DRE. The DRE evaluation, that can take their time. There's 2 as soon as practicable requirements, and that's for the sample. And what's the hell is the other one? As soon as practicable. Oh, for the yeah, that's right. For the sample demand and for the taking of the sample.
Of the urine sample.
Of the urine sample or blood or whatever's taken. So it's the demand. Once the DRE forms their grounds that they're going to ask for a sample, that has to be taken as soon as practicable, and the demand has to be made as soon as practicable. The accused must, the subject must comply with the DRE demand. They must do the physical test. They don't have to answer any questions.
So he won't be charged with refusal if he doesn't answer the questions?
That's correct.
But he'll be charged with refusal if he doesn't appear to be complying with the other requests?
That's right. Okay. And one other demand that can be made by the officer besides the sample is for a breath sample at that point to, if the DRE wants to eliminate alcohol, and that's where the example of the stronger odor in the cruiser comes into play. And you'll notice that's 254 3.3, and that's for one sample. And that's for the DRE's benefit to eliminate alcohol if he wants to, and that's a demand, and that he has to comply with. But he doesn't have to answer questions. However, if your poor fellow wants to tell the officer, he tells you on the phone, he wants to tell the officer, I can't do that test, I'm this, that, and everything. Now keep in mind the investigating officer will have told the DRE that he didn't make him do the walk and turn because of the arthritis and the hip replacement, and he's blurted that out already at the scene. But let's say
but that's not going to be admissible against him at his trial, is it?
No, it just goes to grounds. No, it isn't, just goes to grounds, but that's already been disclosed.
What?
Or likely. But the other scenario, let's say, is a scenario like mine. I have multiple sclerosis. And yesterday I went, but I don't have bad symptoms or obvious symptoms. You wouldn't know to see me walking down the street. Yesterday I went to my neurologist, and he makes me do a walk and turn, which is a heel-to-toe walking with your arms by your side. This is very similar to what the DRE makes them do. I can't do that test. I fall over, into the wall. I'm very shaky. I feel very shaky. It makes me look like a drunk. It's fine in my neurologist's office. But let's say I'm on the phone to Mike, who knows me, and I say, Mike, I can't do these tests, I'll fall over. So at that point, you have a couple of ethical rules coming into play, and since ethics don't apply to crowns, I'll turn it over to Mike to answer that one.
You know, that, I mean, essentially, I'm always telling my client, you know, I don't want you to answer any of the questions from the police. And I'm always telling my client at trial, like, you're not getting in the box unless, you know, unless hell's exploding around us, then maybe you will. But this may be one of those cases where you're going to advise your client to answer the officer's questions about his physical and mental abilities. If you know that he has physical problems that could clearly affect his performance, or mental issues that could clearly affect his performance, this may be one of those cases where you're going to advise him to answer questions. It's a tough call.
It is. How do you assess that when the guy may also have ingested drugs and he's not in a position to waive his charter rights under Section 7 and Section 8?
And where he's not really able to instruct you about what the situation, you know, about his situation, and about, for, you know, often when I'm in Barrie, okay, and most of the officers on the OPP locally and our local force know me, so when they call me at 2 o'clock and say, Mike, I've got a guy here, he's asking for your help, in a case like this, the officer might say to me, Mike, has your boy got some mental health issues, you know? I've got to be really careful. I've just been woken up, but I have a duty of confidentiality to the client. And I've got to really be careful not to say things to that officer that are confidential between the client and I. You know, and our duty of confidentiality goes far beyond just, you know, communication, solicitor-client. I mean, the ethical aspect of confidentiality is very, very broad, and we have to honor it very, very carefully. It's the foundation of a solicitor-client relationship. So,
aren't you going to get your guy charged though if you don't tell him to?
It's a very difficult spot. If I cannot get instructions from the client for me to reveal to the officer the client's issues, then I can't say anything to that officer. Now I can give my client advice, and hopefully he's in a condition where he's aware enough to be able to consider it and hopefully follow it. I can give him advice as to what he should and shouldn't answer in terms of these questions on the DRE form. But it's a very difficult issue.
Is it any different if this is somebody brand new to you? Just picked your name out of the phone.
Well, yeah, it is. If I have a familiarity with the client, if I know his background, if I know he's been suffering depression or is diagnosed bipolar years ago, I'll have a far better feel for it. But regardless, folks, these are things you got to think about when you get that call, you know, from the station and you're asked to help. It's really, really tricky sometimes. And you know, while we're on this ethical side of things, I mean, and not related to our case, but on this, you know, you get a call at 2 o'clock in the morning, and it's New Year's Eve, and you've been out till midnight. You just got home. You've been at a party, and you get the call. I got a buddy here who wants your advice, Mike, and you know, you gotta say, I can't help him tonight. I'm not going to be able to give him advice tonight. I'm not available. You know, I mean, these are things you got to think about when you get those late night calls. And it's not just if you've been out on a party, but I mean, there are times that you can be caught unawares and you're just not in circumstances where you should be giving legal advice to anyone. Perhaps you're sick, you're suffering a bad cold, whatever. These are things you got to think about.
Does anybody have that on their message service? That I will be sober between the hours of. Please call back.
So Katie, on the drug recognition experts form, there are all of these tests that he proceeds through. Now, my understanding is that in addition to questioning my client, he's going to do those same 3 tests that were done back at the roadside?
Yes?
And he's going to do a number of others, correct?
Yes.
Okay,
well,
can
not
you
a
give us
number, 2 more.
All right. Tell us just very briefly, because
Yeah.
I want to move on, but...
Right. And we've got to move on to things like disclosure and training and the drug recognition expert. But these are the tests that they do. The horizontal gaze, again, the walk and turn, one leg stand, Romberg balance test, and finger to nose, which again, finger to nose is one of those from my neurologist's office. So that can be affected by some neurological disorders as well. I'll give you one of the simple ones, and this is the instruction for it. Please, this is the modified Romberg balance test. Please stand with your heels and toes together, your arms at your sides. Demonstrate. Do not do anything until I tell you to. Do you understand? When I begin, close your eyes, tilt your head back. Demonstrate, but the officer leaves their eyes open. You'll see that in the video. Estimate the passage of 30 seconds. When you feel 30 seconds has passed, tilt your head forward, open your eyes, and say stop. Do you understand? Now you can see how many brain processing exercises are involved in that. For someone who's stoned, they may have a lot of difficulty processing that information. Never mind, it's not just about balance. It's about whether they can process, walk and chew gum, essentially, whether they can process information and still do the test. The officer's instructions are to stop after 90 seconds if the guy's still doing it. But one of the these DRE forms that you'll get in disclosure, one of the sample ones, the officers made the notation on the test itself. There's a little stick figure there, and the officer will have notes. The DRE will have notes around that, but additionally, test stopped at 30 seconds, subject falls backwards, stepping back a few steps, and says, my equilibrium is not so good. Opens eyes and breaks stance, and that's what you see in that test. As a rule, a DRE there's no pass-fail for this. As a rule, the DRE is looking for gross impairment. That's their training, gross impairment. So not someone whose estimate of 30 seconds was 29. That's not going to do it. That's not their training. And we'll talk about disclosure and what they get. On the DRE form, they make notations of all the physical tests, and they also complete an essay form at the back. You'll get on the DRE report, this officer's is 6 pages of detailed notes about every step of each of the physical tests and his own notations of the physical signs that he took note of as well. They take blood pressure, they take temperature, they look at pupil size, and there's a card they have to compare the pupil size with what they're seeing. They do it in light, they do it in direct light, and they do it in the dark. That part won't be videotaped. The test is videotaped as a matter of practice. It doesn't have to be. The officer may videotape it. They should, and you should ask for that in disclosure. They also look at muscle tone. They will touch the subject's arm and look at the muscle tone. Tight, tense muscles can indicate a stimulant. Really flabby, limp can indicate a narcotic. That's the only science I'm going to talk about today.
Kate, how long does the testing procedure take, this evaluating procedure? How long does it take?
An hour and 15. It's a long time. They do a lot of tests, and they also look at the subject. Are there needle marks? They mark them up for what they've done. This one, the officer started, the demand was at 5:26. The DRE repeats the demand. And the testing, the urine demand was made at 6:43. So that gives you an idea of how long it was. The officer at the conclusion of all his tests will make a call, if he can, on what classification of drug is involved here, what might be in his system. He doesn't have to.
So he's going to make a call that my boy is impaired by drug.
Yes.
And then he's going to classify, if he can, the drug.
Right. And then he should be making a demand for a sample. 9 times out of 10, it will be urine. If the detachment is next to a hospital, it might be blood.
Does he have to make a demand for a sample of urine or blood?
No, but from my point of view, if I don't have a drug to fall back on, I have a careless from my point of view. And just quickly, because I want to give Daryl some time, I just want to talk about training and disclosure. when you are getting disclosure on these matters, you're asking for the officer's training, so his own personal training. You're asking for the training manual, which is this son of a bitch here. It weighs a ton, and neither of these two help me carry it over here, because we don't disclose it unless, as a general rule, it's not available online. It's available on your case, so ask for the manual. And the manual contains a lot of practice, a section called Practice Test Interpretation, which has these sample DRE forms and how they should be filled out, so you can compare to how yours was. The video, the conclusions, the CFS report, if there was a sample taken, and you want all the continuity officers' notes, because the sample, the taking of the sample, which is not videotaped, all the continuity rules, the CFS seal, the fridge, the officer transporting, all those things apply. The most important thing you need to ask for, though, is something called the rolling log. The rolling log is the officer's own journal of how he's done on these tests in the past. Now, our local officer was qualified. It's a 3-week course that involves actual testing on prison inmates in Phoenix, which is apparently where you get a lot of drug users. They looked for a place in Canada. They were looking at Vancouver, didn't work out, but they requalify every 2 years. In those 2 years, they must do 4 evaluations, one of which must be in the presence of an instructor. So you may have, there's no as soon as practicable, so you may end up waiting for an instructor to come down on your guy to watch the evaluation. And they have to requalify every 2 years, so that documentation you need to get as well. My officer was qualified in 2010. His rolling log is this. He's done 16 drug evaluations. In 6 of them, he called off the impaired. He found no impairment, and the guy walked out. In the other 10, he made a drug call on all 10. On all 10, he made a demand, and a sample was taken. On 9 of those 10, the sample disclosed the presence of drugs, at least one drug that was in the classification of drugs that he called. So it's a match. In other words, he was right about at least one drug. In the other one, there was a combination of drugs used so that ultimately the symptoms mimicked the classification of drug that he called. So that rolling log is a pretty good one. You won't, not everybody does that well. He's a really good officer. That rolling log may disclose that he's done 10 samples, and on 5 of them he was wrong. So you have to have that in your disclosure. So I think that's it for me.
Okay, let me just say a couple of things. Katie's given you an example of a really good drug recognition expert's rolling log. You got to know that some of these guys are nowhere near as capable. In fact, there was one up in our region that early on, when the legislation came into effect, this fellow charged a number of drivers with impaired operation by drug. And the Crown ended up withdrawing all of those charges because when the CFS report came in, the sample did not detect. All right? So that particular officer's rolling log was a complete disaster, and as a result, that officer is no longer doing these investigations. So you really want the rolling log, you really want the video, and you want that written report from the DRE. You know, I was telling Kate briefly about a case where I've had where on the video, the officer sits down with my client after doing the tests and tells him, I formed the opinion you're impaired by drug. And then 3 months later, we get the report, and the report says, I've been unable to conclude impairment by drug. All right? So on the video that came early in disclosure, I might have advised my client to enter an early plea. The officer says in this video to my client, you're impaired by drug. And I ask for the report, and it doesn't come, and it's delayed, and 3 months later I get it, and it says, I can't conclude he was impaired by drug. There is evidence he had ingested drugs earlier, but I cannot conclude his ability to operate the motor vehicle was impaired. So make sure you get the training manuals, the rolling log, the video, and the final report, as well as Daryl's analysis of the sample. Just very quickly, a couple of issues that we don't have time to go into. You know, is the DRE officer at trial an expert? Are you going to go through a Mohan qualification, or are you going to try and get him to give opinion evidence short of an expert as per Mohan? These are things that have been dealt with in other papers that we've had from the 2010 conference, and also from the Impaired program that's put on by Steve Price and Erling and others. So there are papers out there about that. We don't have time to go into it today. I want to go to Daryl. So Daryl, we understand that the officer has taken this sample of urine. By the way, I'm not sure how he gets it. Is it videotaped? Does he watch the guy or the gal pee into the bottle? Does Buddy go into the washroom and just turn on the tap and pour water into the bottle? I don't know. But in any event, you get something, and what do you do?
Well, I get something. Early on, I used to get them in unsealed containers, which gave me a little cause for concern. Now, generally, they are sealed. They are a specimen container that you would regularly give your own urine sample in if you go to the doctor's office or what have you. And upon receipt, I also get a synopsis from the officer. I get his face sheet and all of DRE materials. That is not something that I specifically rely upon for my testing. I have a more or less generalized approach that will catch most, and I clearly say most, not all drugs that are out there that are relevant to impaired driving. I will only test for some drugs if there's a specific request for them, if the officer is looking for a specific drug. But mostly we do a screening mechanism, and as has been pointed out, for the most part it's in urine, which ends up with a yes or no answer. There are very, very few drugs that are in any way, assist me, in my opinion, if I have a number on it. So what you get is a whole list of drugs detected or not detected, such as it is. My practice is that I really don't even look at the DRE evaluation or the conclusions until after my case is done. I may look at it when I'm finished my report. I might just casually look at it then. 9 times out of 10, I don't actually look at it until I know that it's going to litigation. And even then, it's just curiosity more than anything else. I don't use it to inform myself. I don't use it for my opinions, nor do I seek to validate the DRE opinion. I'm simply there as a forensic toxicologist to give you opinion evidence, well, to tell you about my analysis and give you opinion evidence about the potential effects of these drugs.
Daryl, when you conclude that something is detected, I mean, does that mean that there's drug in the body?
Interestingly, with a urine, no, it doesn't. Urine, save for one sphincter, is outside of your body. There's only one valve between your bladder and it going into the toilet bowl. Once it's in the urine, it is a stored sample, and it could be likely, but not absolutely, is in the body, but it's an indication that there's been past exposure to or use of a drug. And I say exposure for a very good reason. There is enough evidence in the scientific literature to show that there are one commonly encountered drug, in other words, marijuana or THC, the inactive metabolites, be aware of the words I use, inactive metabolite, can be in the urine for several hours, not hours, weeks in some cases. And that is, in my mind, indicative of the potential that this person used a cannabis product, but I can't scientifically ever be in a situation where I'm absolute. I can only say that if I see this carboxytetrahydrocannabinol, which is a real mouthful, but if I find that in the urine, yeah, he could have used marijuana, or alternatively, he could have been a snowboarder in a room full of snowboarders. And I actually can't tell you from a single urine sample if that is the case or not. And I will freely acknowledge that. It's not something any of us as forensic scientists will try to hide.
So you're not able to tell us, although you've detected some substance, you're not able to tell us the amount that was ingested, nor anything to do with the timing of the ingestion.
That's absolutely correct. We are all very, very familiar with drug-impaired driving because alcohol is a drug. But we have to differentiate alcohol because alcohol is something that we have a century of literature on. And moreover, we get a blood sample. So with alcohol, because of the simplicity of the drug and the knowledge we have, we can do all kinds of things. We can do readbacks, we can do calculations on how much the individual had to drink if we know timing. There's many things we can do. With drug-impaired driving, we cannot do that. All we can say is this person had exposure to or used this drug at some time in the past, and even the timing is widely variable because of the characteristics of each individual drug. And if I haven't said it yet, which I don't think I have, this is a segue into there are a lot of drugs in some of these reports. Do not necessarily be afraid of that. There are lots of times where I list 4 different drugs and I comment on 4 different drugs where if you call me up, I'm going to tell you, yeah, they could have been all 4 ingested singly. Most likely it's one drug and those other 3 drugs are a metabolite. And moreover, that indicates to me that your client was on it chronically, which segues into the effects of the drugs and whether or not we need to take into account things like tolerance to the effects of these drugs. All of these things are in the mix for a scientist, and as I say, I will freely give you that information if you call me, and there may be an opportunity if we all, Crown, Defense, and toxicologists, speak candidly that we can narrow issues considerably without even getting to a trial.
Daryl, do you find that happening? Like, do you regularly speak with the Crown who has subpoenaed you to a trial next month? Do you regularly speak with that Crown before going to court?
I try to. I offer it up, and I would have to say that it's a sometimes thing. Next week, just to give you an indication of what's happening in our litigation, next week I have 3 trials. 1 is alcohol, 2 are DREs. So the tides are changing. In one of those cases, I had some discussion with the Crown, but the discussion was he wanted me to validate the program, and my response was, find yourself somebody else. I don't validate the program, that's not what I do. I will tell you what I found and what it means. So I haven't had extensive discussions about that. Sometimes Crowns do call me up. I remember a Crown from Simcoe County calling me up and having extensive discussions. And not just because of me, but probably partly because of what I was able to explain to her. Those charges were dealt with by way of a non-criminal resolution. There just was no reasonable prospect of conviction based on what I could tell from the urine. I'm not suggesting that the DRE did anything wrong. I'm just saying that based on what I had, my response to the Crown is you got a guy on a methadone program who had a cold and was taking cold medication. Based on that and based on the driving scenario that I was given, the driving in no way suggested CNS depression, which is the most common effect for impaired driving. The driving suggested this guy, anybody drive on the 400 going northbound on a Friday night? He was driving like that. He was an idiot. I mean, and that's not a professional opinion, that's a toxicologist. But it just did not fit what I know about the effects of those drugs if this person was actually impaired. And they really could have been impaired by the drugs that were there. There's no doubt in my mind. And there's no doubt in anybody's mind that drugs cause impairment. But what we have to do is delve a little bit more deeply into the specifics of the case. And it's a little bit less like alcohol, because alcohol, I don't think anybody in this room is ever going to argue that if your client has 200 alcohol and that goes in front of a court, the judge is not already going, oh yeah, 200, the guy's impaired. Whether or not I get into the witness stand or not, you've already got sort of you're fighting an uphill battle. With these ones, it's new, it's fresh, it's something that we all have to get our minds around, and the courts are just as confused as the rest of us.
So, Daryl, you will speak with a defense lawyer if he calls you in a case where the Crown has indicated you're going to be called by the Crown. You will speak to us and let us run some of the things by that we might want to cross-examine you upon. You'll be open to that with us?
Absolutely. And in fact, anybody who wants my cell phone number, which is about the best way to contact me because I'm out in trials quite a lot, come see me at break. I will give you, I don't have business cards, because if I give you a business card, it'll be misleading because we're moving and I don't know my specific address or my new phone number, and so it'll be out of date in about 2-3 months. But I will give you my cell phone number, which is not going to change, and you can call me within reasonable work hours, and I will get back to you. I don't have the pleasure of being defense counsel, so people calling me at 2 in the morning are not well received.
Daryl,
there you go.
Daryl, a lot of us defense lawyers are rather suspicious of scientists, and particularly those that the Crown calls on a regular basis. Our experience often is that you speak a different language. You seem to avoid answering a rational, well-put suggestion. Often scientists seem to be off on completely other tangents, answering their own questions as opposed to answering the fine question from the very skilled defense lawyer. So we find it very challenging. I think as time goes on and we become more familiar with our scientists, that things improve perhaps. But you must also see that kind of suspicion in the way that you're regarded. How do you deal with that?
Well, I deal with it by being as open as I can and explaining to people I'm not there to make the Crown's case. And Crowns know this from me too. I've had numerous Crowns pissed with me over the years, but c'est la vie. It's a whole different world. When I started out at CFS over 20 years ago, we had a whole different philosophy. My generation is not that generation from 30 years ago where there was a real issue with Crown, toxicologists, defense counsel. We are all very open. In fact, I think the mantra that we have now is the more we speak to people, the more we engage all of the players, the better it is for everybody. Because nobody wants to go into a trial and have a flippin' pitched battle because people just don't understand. I know that litigation can get heated, there's no doubt. But if you get out in front of all of the information, we can usually figure out where we need to go and what we need to adduce in evidence, and it will be a much cleaner trial at that point. And that's what I want to do. I'm only there to explain the evidence to the court. I don't take an issue with who's asking me the questions. I'm just trying to get that evidence out.
Daryl, can I ask you then, my understanding from you is you will give opinion evidence as to what you would expect to find in terms of symptoms observable with someone who has the detected drug found in your screen, correct? That's what you're going to say at court?
Correct. I am going to speak to the indicia or the symptomatology that is relevant to the impaired driving. Some of the things that the DRE officer will rely on are classic pharmacology and toxicology, and I would be able to say, we've talked about it earlier, pinpoint pupils, dead giveaway for someone who's on opioids, okay, drugs like morphine, oxycodone, things of that nature. Pinpoint pupils are an indication of that. Pinpoint pupils are not subject to tolerance, so they're going to be there whether you're tolerant or not. I cannot comment on a lot of the material or information that the DRE officers do because that's beyond the expertise that I have. I'm not trained in that area. I have not assessed all that, but some things are common. We talked about nystagmus earlier. I've had a case where I testified where the person was impaired by ketamine. Ketamine is a dissociative anesthetic. One of the classic pharmacological responses in dissociative anesthesia is nystagmus. So certainly I can support that. You should have seen that in that case, but it's not always the case. Polypharmacy, use of multiple drugs, is a very, very confusing thing physiologically. Some drugs increase your heart rate, some drugs diminish your heart rate, and the effect of that in combination is something that I can't go to. The DRE officers make their call, they have a matrix. I don't have enough data personally to evaluate if they've made the call correctly, and that's not my role.
So, Daryl, do you find that the Crown is asking you to assess the results in the DRE report and advise whether it's consistent with what you would expect to find with someone having this drug detected?
I found that early on the Crowns were much more concerned about me being able to look at the report and say, yeah, we're all on the same page here. It's become less so in recent years, largely because I keep telling people that my findings are my findings, the DRE findings are their findings, and there is going to be overlap, but let's be clear. My classification of drugs may not be the same as a DRE classification of drugs. I don't classify, I mean, I recognize morphine is an opioid, an opiate, they'd call that, but if I'm speaking to a court about the effects of morphine, I'm speaking about its central nervous system depressant effects, not its analgesic effects. So for me, I may have different classifications, so they may not completely overlap.
So do I take it from you then that you and colleagues are uncomfortable with being put in that position by the Crown and asking to find consistencies, if I might, between observations by the DRE and your expected behavior when you know a drug is detected? So you're not comfortable in making that kind of a, giving that kind of opinion at a trial?
Well, what makes me uncomfortable is getting outside my area of expertise.
Okay, fair enough. So my understanding from you too is that human variability and tolerance to drug, prior usage of drug, are all things that you will comment on if questioned by either counsel, correct?
In fact, I'll probably put it out there during evidence in chief. Whoever calls me is going to have to take what they get. I will give the fullest possible explanation that I can for the potential effects of that drug, and then let the evidence fall where it may.
And very clearly, although you will indicate where a drug has been detected in urine, you're going to make it very clear that you can't say whether that drug was active or inactive at the time of the driving behavior.
From a urine test, that is absolutely correct. I have one urine sample. I do my testing. I cannot specifically tie that to a driving event.
Okay. Daryl, what about the last drink defense? Or in this case, my boy says, I just left the office, or I just left the gym, had a workout, my back was sore, so I lit up a joint to ease the pain. 3 minutes down the road, buddy stops me, and here I am, there's drug detected in my system. Is there a last drink defense available to us in this drug scheme?
Yeah, but I wouldn't use it for marijuana, because it's so, if you inhale, that's the most rapid, other than IV, the most rapid way to get a drug into your system. And with THC, you don't want to start giving the crowd, well, my guy just used it, because that's one of the most clear indications that you're going to be impaired. The use of the drug in marijuana case, it's more tied to the temporal relationship. If you put it out there that he used it within the last 10 minutes, it's not, I wouldn't do that.
I don't want to go there.
I wouldn't.
Right.
Now, if you'd said to me he thought, when he was deadlifting the 300 pounds that his trainer wanted him to do, he felt his back start going out, so he took an OxyContin. Now we're talking about a potential, because it could take half hour or an hour to get to your maximum OxyContin concentration. And if he got stopped prior to that, he may not be under the influence of that drug when he got stopped, but he sure as heck could be an hour and a half later at the end of the DRE evaluation.
Okay. All right. I think, folks, that we're going to move to a question or two at this point. I know we only have 4 or 5 minutes left. There is a question that's come in from the floor. What if reasonable suspicion is alcohol only? Can the officer go straight to an SFST demand and forget an ASD entirely? Kate, do you want to think about that? I'll pass it.
Why would they do that? Why would they do that? I mean,
I have no idea.
I can tell you, he didn't have a roadside.
He didn't have a roadside with him. Oh, okay, so he went to the no, jeez. Yeah. Well, if he has an explanation for the symptoms that he's seeing, and the explanation is potentially alcohol, then he doesn't have reasonable suspicion of a drug. I mean, that makes no sense at all.
Isn't there this problem that there's the section says alcohol or drug?
Which section? Yeah, he's asking whether the section, doesn't the section say alcohol or drug for the, okay. Okay.
Sorry,
Yeah.
Bob, was there anything else said? I'm sorry, was that, did you want to go further with that, or?
No, I don't think you have a reasonable suspicion of drug when you have alcohol there, and no other. I mean, you can go straight to the SFST, the screening, the field sobriety test. You can go and make a demand on that if you've got a guy who's got alcohol on his breath, but also has drugs in the car. If you've got a basis for being suspicious of drugs, then that's what you do. You have a suspicion.
Can I ask, is there anyone on the webcast who has any question?
Just speak up.
Nobody emailed to me, and I received one. It was handed up, I think.
Okay.
That's the one? Okay. I guess we're out of time, are we, Karen? Okay. Well, folks, thanks for listening to us.
I want to thank our panel for their insights, and
Thanks for getting up.
yeah,
That's really-
perhaps if
yeah.
we can
Nobody leaves